through everything. So it seems to me that I have to continue today's hearing, and then I also have to evaluate whether or not the court should issue sanctions for a failure to comply with the mandatory requirements of the Nevada Rules of Civil Procedure. Counsels, I will see you at 2 p.m. in person on the 14th, when the court has to evaluate whether or not there should or should not be sanctions.
Your Honor,
I will see you here in person.
Is that, Your Honor?
Your Honor,
This is
Joel Odou.
Your Honor. This is Thomas Valet. May I be heard?
Tyler Dielmann versus Affinity Lifestyles, case 844-348. Who do we have for this case? This is a Rule 16 conference.
Good morning, Your Honor. Thomas Valet, co-counsel for the plaintiff, Tyler Dielmann. And I apologize, Your Honor, I'm not able to get my video camera working.
Good morning, Your Honor. Melanie Hill, appearing on behalf of Tyler Dielmann as local counsel.
Good morning,
And on
Your
behalf.
Sorry, Your Honor. Joel Odou on behalf of Affinity Lifestyles, Inc.com and Real Water. We filed our remote appearance on May 22nd.
Okay. And remember, on this case, we do have a media request, and so we likely have, looks like we do have media present. But counsel, what I don't like to have to remind you all, what date did you file your joint case conference report? Because we don't see one. That's why I'm asking.
Your Honor, it has not been filed. This is Thomas Valet, Your Honor, for the plaintiff. It was not filed, Your Honor, and I take responsibility for that. I misunderstood the instructions that local counsel had given me. I misunderstood that we were required to file something in addition to the mandatory disclosure that, under the case management order, which we did provide. And I apologize, Your Honor, that the joint schedule was not filed. That's my fault.
Counsel, how can we conduct a Rule 16 conference in the absence of a joint case conference report? That's the very thing.
You can, Your Honor, and I apologize for my misunderstanding.
But counsel,
I am
subject as a pro hoc vice. I know, but please don't tell me because you're a pro hoc vice. Remember, the specific requirements to be admitted pro hoc vice is you will be knowledgeable with all the rules and that you will comply with all the rules. And in fact, you swore to do so in order for this court, under Supreme Court Rule 42, in order for this court to allow said pro hoc vice admission. So.
You're correct, Your Honor, and I apologize. I only meant to indicate that I didn't independently know that, and I misunderstood the instructions that I had received.
And local counsel, why didn't you follow up? This is a waste of time today.
Your Honor, I apologize. We did speak to Mr. Odou about the dates that we wanted to propose to the court, so we were hoping that we could move forward with this and get a trial date set. And I apologize.
What date did you do your early case conference? And who participated? Who's trial counsel in that early case conference, please? What was the date of the early case conference, please?
Your Honor, we spoke today.
Today.
Mr. Odou, myself, and Mr. Valet.
And counsel is a licensed Nevada attorney. Do you think that is compliant?
No, Your Honor. We should have spoken sooner, and we should have filed the joint case conference report timely.
It's mandatory, right, counsel? Within
yes,
a specific date, there is actually sanctions, right? That usually trigger from a failure to do so, including potential dismissal of a case, counsel, right?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor. We had moved this up at the last hearing to do it on a quicker time frame, and I apologize that was not complied with timely. We were just trying to coordinate this case with the other real water cases.
Right, but you do realize, if you remember from the last hearing, the court did specifically remind the parties to do that, right? To do your early case conference, get your JCCR in, because I was asking if the parties wanted this done as a set date so that you could then schedule everything tied to that date. So it is very concerning because, as you know, it's a mandatory process, and the mandatory process needs to be completed prior to the Rule 16 so that we have knowledge of the potential dates and then we can walk through everything. So it seems to me that I have to continue today's hearing, and then I also have to evaluate whether or not the court should issue sanctions for a failure to comply with the mandatory requirements of the Nevada Rules of Civil Procedure. Is there any reason I should not be doing that, that I should be doing something different? Counsels for plaintiff, do you wish to be heard? Then I'm going to ask counsel for defendant.
For the plaintiff, Your Honor, Thomas Valet. Again, I apologize for not complying with the court's directives. I would ask your indulgence and give us some additional time to submit the required filings.
And Your Honor, I was out sick, very sick, the last week, and that was one of the reasons why I wasn't better about making sure that this happened, and I apologize.
I do realize the court's not asking anyone to disclose any of their medical privacy. Obviously, the court wasn't aware of that because the court was not provided any information, any notification, any request to even continue today's hearing to a different date so that the parties could comply. So, and I guess I should be making sure the bankruptcy stay was lifted, right? So court was able to move forward. I understood based on the May 22nd hearing that the bankruptcy stay had been lifted, correct?
That is correct, Your Honor.
There is an order.
Okay. Counsel for defense, any reason why you didn't trigger the idea of a early case conference when you knew about today's date? And I appreciate the last time you were here, you had not yet filed your answer, so that's why I'm asking post-answer my question after May 23rd.
Thank you, Your Honor. Joel Odou on behalf of Real Water and Affinity. We filed our answer on May 23rd. We served our initial disclosures on June 2nd. We did contact the plaintiffs about getting their initial disclosures. We got the information, but not an actual formal 16.1 disclosure, so we followed up asking for that so we could do the JCCR. The parties have been working in good faith to try and get this case coordinated in a speedy fashion, and probably we were over-optimistic in trying to do this too fast. So we would request the court not sanction any party. The parties are working in good faith. We just didn't get it done quick enough, and we obviously understand that we can't take a shortcut on the rules, but we did get medical authorizations. We did get the fact sheet completed, which is required by the case management order, and we're just missing a formal 16.1 from plaintiff's statement of damages. I spoke to counsel this morning. They're working to get that to us in good faith, and so we did also talk about the fact that there are 13 other real water cases set for trial, and we can certainly have our JCCR on file fairly quickly. But the court is correct. There has not been a full early case conference as required by the rules yet.
Counsel, would you say that what you did by speaking this morning even counts anywhere within the rules?
I think it counts for one part of the rules, but not full compliance with the rules.
Counsel, you already had the notification. You already knew what today was. What part does it comply with?
Only that the parties have conferred about mediation and trial in numerous emails. The parties have not. Well, we've also conferred about the length of discovery because the plaintiff is a VA patient and discovery will take longer in this case. But we have not gone line by line through every single part of 16.1 and fully complied, but we have partially complied with that.
Plaintiff told me they did not set up an early case conference. They spoke this morning with you. Counsels, I will see you at 2 p.m. in person on the 14th. Will be your continued date for Rule 16. I will also evaluate on that date whether or not there's been appropriate compliance and what, if anything, the court should do, because that should give you sufficient opportunity to A, get things done which you're supposed to get done, and B, to the extent anybody wishes to present anything to the court, when the court has to evaluate whether or not there should or should not be sanctions as a result of the non-compliance. And yes, I am appreciative that the Pro Hoc Vice wasn't even submitted to the court until mid-June, and so I'm not sure why somebody would be participating in litigation Okay, but we'll be addressing all of that on the 14th at 2 p.m.
Your Honor,
Your
may I
Honor.
interrupt?
I will see you here in person on the 14th at 2 p.m., folks. That's what we're
Is
going to
that,
do.
Your Honor?
Your Honor,
This is,
Joel
Your
Odou
Honor,
for
this is,
Real
this is
Water.
Thomas Valet. May I be heard?
Excuse me,
I
I have
am-
two people interrupting each other. The court has set the hearing, right? I need to set the hearing. I've given you more than a week. It's going to be on the 14th in person at 2 p.m. You will need
I
to
cannot
give
be
joint
here on the
case
14th,
conference.
Your Honor. I am out of town. I've already paid for my vacation. I would request it go to the next week.
What dates are you out of town, Mr. Odou?
I'm out of town July 10 through 14.
That's why I said the 14th, though. I said Friday the 14th.
Yes, I am out of town on the 14th, Your Honor, July 10th through 14th.
I'm sorry, I thought you said the 13th, counsel. And I'll
I
see
can do
you
the very
Monday.
next week.
Excuse me. Then Monday, 8 a.m., because I start trial. I've got jury selection time. It has to be 8 a.m. So I got special settings at 8:30 that I have to do before the trial starts. I will see you 8 a.m. Let's make it 8:15. Let's do it 8:15 on the 17th in person. Will be required. And our CP 16 requires realistically in person anyway. If you look at it, it really doesn't even allow the remote. That being said, necessitated because of the conduct currently in this case, we need to have you here in person. The court's going to find good cause to require in person so that we get this case started appropriately on track. We already have issues about compliance in the very early stages, which we want to make sure does not happen. So the court's going to find that that is appropriate. 8:15 on July 17th. I will see you here. That means you have to have your joint case conference report done the week before. That means you have till Monday, and you'll provide this court a courtesy copy by Monday the 10th at 4 p.m. with regards to said joint case conference report. So I'm sure you all will be spending some time this afternoon making sure you've done everything so you can get that taken care of so this case can move forward. We need to ensure, remember, it's your ultimate clients as well who have the right to have their cases move forward in a prompt and expedient manner consistent with the rules. Is there anything else the court can do for the parties other than wish you a great rest of your week? On
Your Honor,
case number 844348, which is page 24.
Your Honor, this is Melanie Hill. I'm actually coming back that day from a weekend trip out with our Girl Scout troop to Legoland. Would it be possible to do it on Tuesday in person?
Offering you the same accommodation that I offered opposing counsel. You can do 8:15 on the 18th. Yes, you can.
Thank you, Your Honor.
Okay, sure.
Thank you, Your Honor.
Best of luck on
Thank you, Your Honor.
trip. I already have accommodated one each side, so we will make sure the 18th at 8:15. Unless somebody has a medical appointment or some good cause, then why, counsel? Is there some other issue for now the 18th?
No, Your Honor.
I'm sorry, was somebody speaking? I wasn't sure. I didn't see
This
anybody.
is Thomas Valet for the plaintiff. The 18th is fine, thank you.
Okay.
Defense agrees. Thank you, Your Honor.
Thank you, Your Honor.
And you're back? Okay, so, see the 18th at 8:15. Okay, your date for your joint case conference report is still the 10th. Okay, with the courtesy copies of the court, please. Please do have compliance with the rules so that your counsel and all clients are appropriately protected and the case can move forward in an appropriate manner. Is there anything else the court can do for the parties on case 844348, page 24?
Not for the plaintiff, thank you, Your Honor.
Thank you,
Nothing
Your Honor.
further for the defense.
Okay, do appreciate it. Have a great, like I said, rest of your day. Hope everyone had a very nice 4th.